the cloud. Hi, everyone. My name is Tara Spalding. Welcome to Boom Startup Accelerator's Open Up series. Today, it is my pleasure to have Tiffany Shimada as our special guest for trademarks and trade dress for startups. This is a really important topic. It's something that you got to think about at a very early stage, and it's very important as well to investors when they're figuring out your company valuation. It starts with the value and the protection of your brand. Before we get into the details, I would like to say thank you so much to Boom Startups Accelerator sponsors. We like to thank Assure, Greenberg Traurig, Now CFO, 212, Outcode, and Lateral Solutions. If you're new to Boom Startup, welcome. It's our pleasure to have you here with us. All of our programs are online and opt-in, so join our live as well as on-demand programs that fit your needs to help you grow your business and become a better operator. Boom Startup helps founders break through the barriers holding back business growth. And we love founders that commit with grit. We leverage not only our platform, but also experts such as Tiffany to help mentor you through very real situations. Now, when the timing is right and your business is showing traction, we'll invite you into our investor community, which we'll talk about in a minute. 2021 was a banner year for us. We had 1,013 companies from 49 countries participate across the world in our various programs. The great aspect about this is that the industries were quite varied, yet all of these founders were figuring out different paths to capital, either through sales and revenue generation activities, as well as debt and equity. We measure success when you, the founder, really figure out how to improve your business through the maturity by giving you guidance. We love talking about investment preparation, also capital structuring and investment strategies. For a superset of our participation, we can vouch for your company's authenticity, because every time you participate in programs like this, be they live or on demand, we can track your participation, your engagement, as well as even your meetings with mentors, like with even Tiffany. And for a superset, we'll help you raise your first $100,000 through our syndication and our acceleration program. Boom Startup has 4 programs. First is our international pitch competition that we hold a few times a year called Pitch Up. Next are OpenUp webinars, as well as toolkits and mentor meetings. And we also offer a little bit more in-depth, deeper programs through our Rise Up sprints, which last about a week. And then, of course, we have our Amplify Up invite-only cohort, which runs 12 weeks long. And their Amplify Up cohort helps fund high-growth potential startups with the right capital and investor support. If you're interested in applying for Amplify Up, please go to boomstartup.com/amplifyup. Amplify Up handpicks companies and founders that are proving with commitment and grit, as well as traction and the trajectory that they're going to have some incredible growth going forward. We help formalize the pre-seed investment preparation for startups from around the world. And in fact, our last cohort, we even had a company from Croatia. We help audit and screen the deals. And we also connect you to angel investors who have the appetite for that pre-seed funding. Additionally, we provide funding through the Assure SPV. Investment opportunities are also available for investors that are within the United States as well as outside of the United States through these SPVs. And then last, the funding organization is handled by Boom Startup. Now, it is my pleasure to introduce Tiffany Shimada. Tiffany, thank you so much for being here today. And thank you so much for talking about trademark and trade dress basics. I love to just start off with a very simple question, Tiffany, which is, can you tell us a little bit about yourself and why this topic is so important to founders?
Well, absolutely. Thank you, Tara. It is a pleasure to be here and to present on these topics. I love branding. It's something that, from a very little kid, I would notice. And as a lawyer, it's, of course, my day-to-day work with marketing teams, with counsel, with businesses, entrepreneurs, people who are really just trying to identify what they do and be authentic about it and communicate that to both customers who already exist and potential customers. It's basically look at your calling card. That's what your brand is. That's what your business is going to be called, what your products are going to be called. And so I just really enjoy counseling clients in this space and with just talking about, again, identity of your company and your brand is one of the most essential pieces. So that's in a nutshell the type of
That's,
law that I practice.
yeah, no, that's fantastic. And I think you're right, because it's so core to business and communities and so many other aspects. Anyways, Tiffany, thank you so much for presenting today. And I will mute myself, and please tell me when you want to progress on the slides.
Okay, perfect. Well, the next slide is really just my information. I am a shareholder at the law firm of Greenberg Traurig in Salt Lake City. We are a multinational firm with 43 offices and over 2,500 attorneys. I am grateful to be a part of a robust trademark and brand management team. And you can go to the next slide. Because we will introduce what I'll be talking about to you today. And just very generally, when we say intellectual property, what are we talking about? Generally, you think about 4 buckets, and that's trademarks, copyrights, patents, and trade secrets. I'm going to begin by saying what we're not covering today, because we're going to cover it later in this series with me and Boom Startup. We'll be talking about patents at another day, as well as copyright. Today, we're really going to focus on the 2 bookends of the spectrum, trademarks and trade secrets. They go nicely together, and you'll see why in a moment. I just want to explain, again, just very briefly, what we're not talking about. Copyright are protection over expression. So that's where you're thinking about books, movies, computer code, basically any written expression that's caught in a tangible medium. Films, those types of content are going to be held under copyright protection. I will also not be talking about, and not at length at least, about patents today. Patents protect an invention, a process, a system, or in some cases design, which we'll get into a little bit. But those are the 2 areas that we will address later. If you go to the next slide, Tara, I will introduce trademark. And trademarks, you don't have to be a practitioner of the law or even a marketing person to understand what a trademark is. All of us have seen these symbols. TM means trademark, SM means service mark, and the circle R, as we love to call it, means it is a registered trademark. These symbols are used in the United States and in other countries to just identify that a particular phrase or tagline, or in some cases, other distinctive types of marks are registered, or that the owner of the mark has an intent to make a trademark use of that particular phrase or whatever the source designation is. So we'll get into it, Tara, on the next slide. What is a trademark? It's words, symbols, designs. I mentioned slogans and taglines, product shapes, colors, smells, and sounds can be trademarks. There are lots of famous ones that you might think about, like Tiffany blue, or the smell of Play-Doh is protected. The sound of the NBC chimes or the MGM lion, those are all source designators, source indicators of particular products or services. And we appreciate them as consumers because it helps us to recognize the source of those goods and services. So we know what we're getting, where we're getting it from, who actually produces those goods or renders those services. That is all what trademark law is about. Next slide. And one of the most important things to think about as an entrepreneur or as a business owner, when you're thinking about selecting a trademark or using a trademark, You want to think about the strength of that mark. We certainly are all familiar now with a Google or a Xerox or a Rolex, but at one point in time, those words did not exist. They were coined by the owners for particular goods, and we know them, and we know them well today because no one else has a reason to use those terms. They were coined by their creators. Those are going to be the strongest trademarks that you could have. It's easy to protect them. It's easier to enforce them. Why? Because they're made up words. Now, not everyone has the benefit of coming up with a made-up term for their good or their service. So I'd say most trademarks live on the left hand of the spectrum. If it's a generic mark, it's not capable of trademark registration. You can use it, but so can everyone else in the world. So escalator, aspirin, and cellophane, these are all examples of words which were once protected by trademark. But the owners lost protection, at least in the United States, of these the rights to the exclusive rights to the use of these marks because they did not police the use of the marks, meaning that these terms fell into common colloquialisms, just speech that people use about certain goods and services to the point where those goods became aspirin, those goods became cellophane. And so there was no distinction between one particular source of those goods and other third parties. So you can have a mark and lose it to genericide, again, if you're not careful of policing your mark, making sure you are the exclusive owner of your mark through various things like licensing and enforcement. And we'll talk a little bit about that later. A lot of marks are in that descriptive area. Descriptive mark means that it describes in some way a characteristic or a component or some attribute of the goods or services that you're selling. And so I have some examples here of descriptive marks that went on to achieve protection. American Airlines, Sharp for TVs, and other electronic goods. Holiday Inn for places to stay when you're on holiday or on vacation. But because these marks over time have become source identifiers for one particular owner, we know them as trademarks. And that is the only way that you can protect a descriptive mark, is that over time, you build that distinctiveness. And we call it acquired distinctiveness, secondary meaning, because we know the sources of these particular services and goods. They can be trademarks even though they're descriptive. The best kind of juiciest place to be on this continuum, aside from the fanciful marks, is if you have a suggestive marks. These are stronger marks because they kind of hint or suggest at the meaning or a characteristic of the goods or services, but they don't just tell you. These are your Netflix, your Airbus, your Coppertones. You can have an idea of what it is, but you can't exactly guess unless you're looking at the product and you look at the word, and then they can kind of come together. And just lastly, after the suggestive, you go to arbitrary marks. Then we're looking at marks or words that have meaning in other contexts, but in connection with these particular goods and services, they're arbitrary, so they're protectable. So for example, you can't protect apples if you're selling them with the word apple, but you can if you're selling computers and so forth. So we can go to the next slide, Tara. That's just an examination of the continuum. Essentially, you want to be on the right side of this and not the left side. It's just going to give you less headaches. So again, we talked about selecting a trademark. You want a stronger mark. You want to start early, as Tara had mentioned, in the process, because you don't want to get all the way down the line to having a product, it's already packaged, it's already being distributed, and you find that you need to rebrand, or there's someone else out there with a similar name. So you want to start early. You want to search. You want to conduct an availability search of whether you can use the mark and whether you can register the mark. And those are two different things. And it's really important to think about, just because you use something doesn't mean it's registrable, and vice versa. You want to focus on where trademarks are territorial. So if you are mainly going to be in the US, maybe you only care about trademark protection in the United States. But if you are going to be rolling out your product or your service, you're going to be online, selling in Europe or Africa or Canada, then you need to also apply to register your mark or to see if it's available in some cases for use in those countries so that you don't infringe on third parties that might already be in that market. Things to consider in addition to just whether or not you have a strong mark, or what does it mean? Does it have a phonetically similar meaning that might be detrimental to your brand? Are there foreign equivalents out there that already exist, particularly in other countries? You should be thinking of all these things early in the process. And again, I look at the legal risk to use and register marks. You also want to consider as a brand owner, what are going to be some reputational risks of adopting a mark? And I'll give you an example. Kim Kardashian had a line, she came out with kimono for undergarments and received a lot of backlash, just thinking about cultural appropriation issues or cultural issues in general. Sometimes you might select a word because you like it, but you really haven't done much research in terms of what it means to a community or what it means in the context of the goods or services that you're selling. So you want to be careful to examine all of those issues before you apply to register a trademark. We can go to the next slide. Filing, you want to ask yourself again these same questions. Territorial and where you're going to be, you're going to want to file early in most jurisdictions, because outside of the United States, the rest of the world mostly is a first to file type of system, meaning that trademark rights come from filing, your date of filing and registration, and not necessarily from the first time that you used a mark. So you want to be thinking about timing, the basis of your filing. You want to make sure that the owner is listed correctly. If it's the subsidiary who actually controls the goods and services versus the parent company, then that subsidiary should own the mark. You also want to think about maintenance. It's not you file and then you're finished. There's certainly a process that you go through with the trademark office in every country where you actually prosecute the application before an examining attorney on the other side who works for the trademark office. So you want to think about timing. It takes at least a year in most jurisdictions to obtain registration, and now up to 3 and 4 in some countries. You want to think about maintenance, because again, once you file, every so often, typically 10 years or so, it varies by country, you're going to have to renew your registration. And so that's an ongoing cost that you want to build into your business plan, and you want to build into the investment of your marks. And it might also affect how many marks you file and in how many jurisdictions, because that cost, again, it's going to be ongoing. Next slide, Tara. And why does this even matter? Why can't you just use a trademark and just go from there? Well, trademarks in their essence are really not about an owner. They are to an extent. Trademarks are more about consumer protection. So remember at the beginning where I was talking about, we know as consumers where to go to find goods and services. That is the basis of trademark law. We have these source indicators to prevent confusion in the marketplace, so that if I want a particular type of sandwich and it's a Subway sandwich, I'm not going to go to Burger King and ask for a spicy Italian cold cut sandwich. I know where I want to go for that. I know who provides it, and I know what's supposed to be on it based on, again, the reputation, the menu, things that I've come to know from my buying there before, and from other consumers buying there before. And so you want to think about trademarks as really protecting the goodwill and the reputation of a company. And it's not just an intangible asset in itself, it is on the balance sheet. These trademarks are valued. They have very high value for most brands. And so you just don't want to think about, again, selecting something just kind of out of the blue. This is going to be something that has value, that you're going to be reporting on, be you a private or a public company. You're going to have to think about the value of your brands as a line item. Some other issues, registration, at least in the United States, I'd mentioned, is not necessary, but you do want to have it in terms of thinking about enforcing your mark. in terms of, just being able to police your mark. It's so much easier if you have a registration, something you can point to as a piece of paper from the trademark office saying you own exclusive rights in all 50 states and US territories. It just puts you ahead of the game. And infringement, I just want to touch on this for a moment because we'll come to it again at the end of the presentation. Infringement, it really depends on, again, the type of mark, but it depends on also the goods and services that are covered. So I'll give you an example of a very well-known mark, Dove. If I just say Dove, you might immediately think of chocolate or you might think of soap. Two completely different areas of goods. No one is confused when you see it on the shelf as to which one we're talking about or thinking about. But that's just one example to where you can have multiple marks be registered for very different goods and avoid consumer confusion. So a trademark does not give you exclusive rights over all goods and all services everywhere. It gives you rights in a particular scope of goods and services. And that's really important to be thinking about when you file your application and as you think about growing in terms of where you'd want to be and enforcing in the space that makes the most sense based on your business model. So we can go to the next slide, Tara. And I'll pivot to trade dress. Trade dress is different. It's related in some respects, but not related in others. So I'll first address trade dress and its meaning on the next slide, Tara. And this definition comes from a case, it was a Supreme Court case about two Mexican restaurants that where 2 pesos had infringed on Taco Cabana's internal and external kind of design of their restaurant. They had this theme that was very colorful and very well known in the areas where they were operating, and 2 pesos swiped that. And the Supreme Court allowed Taco Cabana to enforce registration in trade dress of its restaurant. And so think of trade dress very broadly. It started out as protection over product packaging and things like, the actual wrapping of a product, but it's since become a much larger area of protection where we now think of trade dress much more broadly. We think about designs of restaurants and design and configuration of products, colors can be trade dress. So think broadly, again, these are source indicators beyond words or symbols. We're talking about actual image and appearance of a thing being a source indicator. So if we go to the next slide, trademark or trade dress can be registrable as trademarks, and but there are specific limitations. So if it's functional at all, we'll talk about this in a minute. We'll be looking at patents instead of trademarks because trademarks, as a rule, cannot be functional. We're also going to look at, is it distinctive? Because if it's not distinctive, meaning that other people need to use it, it's not specific to one particular owner, then we've already talked about that. You can't have exclusive rights over it because it's not a source indicator. So that might seem like circular reasoning there, but I just wanted to differentiate between trade dress and whether or not it's protectable as a trademark. And when we think about distinctiveness, there are 2 ways to get it. It's either inherently distinctive, meaning as soon as you see the thing, it's unique, it has nothing to do with how the product functions, and it's registrable as a trademark. And then we have that acquired distinctiveness. So just like I mentioned with, Holiday Inn, over time, they have built that distinctiveness in that mark, even though it's descriptive. The same thing can be done with types of trade dress that are not considered inherently distinctive. And so we'll get to some examples, I think, on the next slide, Tara. Yes. So these are all really famous examples of trade dress that are registered as trademark. And I pulled here, these are the drawings that are actually on file with the US Patent and Trademark Office for each one of these types of intellectual property. And we all know the chocolate that's at the register that we just pick up. We know it by the look, we know it by the feel. I know it by the smell because I love chocolate. So we have Ferrero Rocher here, and that is obviously a very, very famous type of chocolate. Burberry and the print that is on everything from purses to shirts to pants. That particular grid pattern is protected by law, by US trademark law, under that registration listed here. And also, we all know and love vehicles. That Porsche look and feel that we see is protected again by trademark. And you might say, wait a minute, isn't some of that functional? But not really. I mean, you don't have to design a car in that way to look that way. That is something that a lot of engineers worked on to make sure, it is an automobile, but the particular design of it is what is distinctive and what we've come to know as a Porsche. So next slide, please. So I mentioned that there are specific ways to protect trade dress as trademarks. You should know that trade dress can be protected under copyright and patent law, but it has to follow other types of rules. So I'm not going to get into the weeds, but I will say that if it is sculptural or architectural and it is unique or distinctive in a certain way, you can have copyright protection over trade dress as well. You can also have patent protection over trade dress. If it is functional, you're thinking about a utility patent, which requires novelty and that it be non-obvious, meaning no one has thought of this before. It's not obvious from the inventions that are already out there. So that's something to think about. Just caution, if you do pursue a utility patent for something that is trade dress, then that precludes copyright and trademark protection, because you can't have functional elements be in a copyright or trademark. If you have a design patent, that is specific for protecting, ornamental features and product configurations. So that's another type of protection under patent law that you can pursue. And you could, in a way, also have trademark and copyright protection if you have subject matter that is eligible for a design patent. So talk to your attorney, make sure that you are pursuing the right strategy for your particular product or your particular service if you are interested in trade dress protection, because again, if you pursue the wrong route, then you can preclude protection in a different way. Why is this important? Well, we'll talk about terms in a minute. Go to the next slide, Tara, please. This is why. Trademarks are forever. Meaning, as long as you are using that trademark in US commerce and you renew your mark, you file your required documents when they're due, you have trademark protection as long as you're offering that in US commerce, as long as you're selling your goods or rendering your services. Other types of intellectual property have different terms of protection. So copyright is fairly long. If you're an individual, it's for your entire lifetime plus 70 years. So taking care of, future generations. Most copyright for entrepreneurial or small business purposes is going to be a work made for hire. So again, it's quite long. It's either 95 years from when the work has first been published or 120 years from creation, whichever ends first. So again, fairly long term of protection, but not forever. Utility patents are 20 years from the filing date, and essentially, and design patents are 15 years from the grant date. Again, you want to talk to an attorney about your specific intellectual property and the terms related to that and what's most beneficial for you. It's important to remember that trademarks and patents, utility patents, have renewals that you have to pay to keep them up even during their terms. Copyright and design do not. So there's some, benefits and disadvantages to each type of IP, but you want to make sure that you know what you're doing before you file so that you can work with someone to help you meet all of those guidelines and, stay within the parameters of protection for that particular IP. Let's talk a bit about controlling and enforcing trademarks and trade dress. So these are just some suggestions. There are other ways, but these are ones that I would strongly recommend you think about in terms of controlling and enforcing your trademarks and your trade dress. So again, you don't end up on the generic side of that continuum, or so that you don't, inadvertently lose rights. Brand guidelines are something that are very important as a trademark owner. You want to make sure that internally, your team, or if it's just you or and your marketing person, are following the directives of your mark. So there are certain things that you should not do as a trademark. You shouldn't pluralize it. You shouldn't make it possessive. If there are specific colors that are really important to your branding, down to the Pantone, you want to make sure that your marketers are using that in the materials in the right way. And this feeds into licensing of a brand. You want to make sure that you keep control as a brand owner into how people are using your mark for goods and services that are offered. Your licensing scheme should have a good quality control provision in place, both in the contract as well as in practice. It's not enough to just have it in writing. You actually need to be doing these quality control things to make sure that you're keeping control of those goods and services, because again, at the end of the day, your mark is on that product or service. That is your reputation and your goodwill. So you want to make sure that you keep tabs on the quality of those goods and services being produced, because that ultimately does affect your bottom line and your reputation. You want to, after you own the trademark, look at watch services. Watch services are simply third-party services. They will look to see if anyone is registering a similar mark or an identical mark in similar classes of goods and services. So that's just, again, a warning sign to let you know so that you're not constantly looking. Sometimes your customers will let you know when there's an infringement issue, but it's really good to watch the registries. It's really good to watch online what is happening, whether or not you want to set an alert through a search engine, or hire another party to monitor for infringing uses. It's something to think about in terms of protection. Once you find that someone is misusing your mark, via a competitor, or even a customer sometimes might make reference to your mark, you just kind of want to course correct. You can do that in a number of ways, but most often we use demand letters, and that's your classic cease and desist, saying please stop, and they can be very nice letters and they can be very draconian letters. It just kind of depends on who's doing the infringing and how bad the situation is. But again, you want to talk to your attorney and do some due diligence before you send a letter. So that's really important to think about. Once you start a letter campaign as well, then you're putting the other party on notice if it is infringing. And so that feeds into, if you're eventually going to file a lawsuit, how quickly you do it. So just be thinking about ahead of time what you're asserting and how far you're willing to go to enforce before you send a letter. And same with oppositions, cancellation proceedings. These are typically proceedings that are conducted before a trademark office, so they are administrative in nature. In the United States, we have the U.S. Patent and Trademark Office's Trademark Trial and Appeal Board for trademarks and trade dress, and so that's typically where those cases end up. And that's where case law is set. In the real world, outside of administrative law, we have state and federal courts. And I just want to mention, state and federal court is really the best way to enforce against use of a trademark that is unauthorized. Oppositions and cancellation proceedings can help you as an owner keep a third party from registering an infringing mark, or getting exclusive rights to that, but that's a separate right entirely from being able to use a mark. That can only be determined by a state or federal court that has the power to enjoin use of a mark. And next slide, Tara. This might be our last one. I've been going through these fairly quickly. But this is we could spend a little bit more time on this slide too, and just thinking about fair use and non-infringement. These are areas that really define the scope of trademark use by third parties. So fair use is a concept that, it's, yes, I am using someone else's trademark or trade dress, but it is fair because it meets certain factors in a test. And for trademarks, it's really important to think about fair use in terms of, are you describing that other companies or other parties goods or services? If I claimed that, I have a type of shoe and I love running and I call it a Nike shoe, well, that's just a fact. I have described the type of shoe it is, where I got it from, it's a source indicator. I'm describing what I own. If, however, I go on and, paint my entire website with orange and white and, make it look like I'm somehow affiliated with the Nike brand, then that is going beyond what I need to do to say I own a pair of Nike shoes, right? So there are certain things that, and again, it depends on who you are, what you're saying, and where you're saying it, but think about fair use in the context of free speech, if that's helpful. So if you're a competitor and you want to talk about pricing of your product versus your versus other parties, or you want to talk about whether or not your product is compatible with another product, there are things that you can do within the confines of free speech to say, to state a claim, as long as it's truthful and it's not deceptive and it doesn't create a connection to a brand that doesn't exist, or an affiliation or a sponsorship, then likely it's okay. But you want to make sure to run your use by an attorney in this area who knows advertising law if you're unsure at all as to whether or not your use is okay. Criticism and gripe sites, you see this all the time. Those are typically going to be covered by free speech, at least here in the United States. Same thing with commentary and reviews. Most business owners do not want to go after fans, but you might want to go after someone who leaves a negative review. I would caution to look into that with your IP attorney. Make sure that, what you want to do in terms of enforcement isn't anti-free speech, that people do have a right to say whether or not a thing is good or bad. You don't have to, though, then, decide to enforce on that if you don't want to. Let's talk about non-infringing uses, because these come up quite a bit in advertising law. Keyword advertising has been found time and time again, in most cases, to be a non-infringing use. Now, there are times when it is, again, if you're using more than what you need to promote a product as a keyword, then that can certainly create an instance of infringement. Expressive works, for the most part, are non-infringing uses, meaning, someone refers to a good or service in a book or in a movie, unless it's going above and beyond and making what's happening look as though there is a connection there, or some type of deceptiveness is going on, it's going to be allowed because that's considered free speech. Also think about upcycling, reselling. Those types of uses in referring to a brand are not infringing uses. And other non-trademark uses like social media tags. Sometimes hashtags are non-infringing uses. Sometimes they are. It depends on how they're being used. If they're used mostly to just catalog information, then no. But if they're being used as a source indicator, then again, you'd want to talk to your attorney about whether that rises to the level of having to enforce. And so I wanted to spend some time here because these issues come up quite a bit for brand owners. And particularly where you have competitors and you're trying to kind of elbow your way in a market, these are issues that come up quite a bit. So I just wanted to touch on them high level, but again, if you have a specific scenario, a lot of fair use and non-infringement of trademarks are going to be fact specific and handled on a case-by-case basis. So you want to talk to your attorney about these particular issues. And next, Tara. I am open for questions. You can contact me anytime. I know I ran through a lot of these materials quite quickly, but I just wanted to high level give you an idea of what trademarks and trade secrets, not trademarks and trade secrets, trademarks and trade dress are, how to protect them, and really how to make them a part of your business day-to-day thinking and planning long term. Because again, they're your calling card, and they're going to be how people come to know you and how they come to find you.
Oh, I think this is a fantastic presentation. Tiffany, thank you so much for the information. Couple of questions
Sure.
for you. First, when it comes to transferring trademarks or transferring trade dresses from one entity to another, how is that done? How would you consider this? Or like, what are the different points that a founder should consider when possibly taking over existing brands or trademarks or trade dresses?
Very good question. I think that in any type of transfer, you want to do some due diligence at the very beginning. Make sure that, whatever you are acquiring is owned by that particular entity, and that they have the rights lined up, whether they be registered rights or if it, common law rights, that they can be easily identified and listed, so that when you have that transfer agreement, which is typically an assignment, or maybe it's a license, you can identify the intellectual property by number or by title and where it's registered. And then once that's done, you want to clean up the record with the respective trademark or patent or copyright office, and make sure that that ownership transfer is recorded, just for purposes of maintenance and for notification if there is infringement.
Tiffany, when you do a transfer, does it reset the clock for the different ownerships or extensions that you mentioned earlier in your presentation, or does the timeline not change, just the ownership?
Just the ownership changes. So all of the terms are really based on registration or filing dates, and it doesn't matter who the owner is. Once you do have a transfer of ownership, and this is why due diligence is so important, you want to think about, what is the next maintenance deadline? What do I need to do to, get the papers in order so that when I renew, I'm renewing in the name of the rightful owner. So that's why it's really important, as part of that due diligence process, to also find out what the deadlines are, because your rights are going to stem from those particular filing or registration dates of your IP.
Okay, no, that's really good information. Drilling into due diligence, for example, when you're searching trade dress, it's been stated that if there's like a 10% or more derivatives, then trade dress protection just doesn't stand up. That in fact, you can have a separate trade dress submission. Is that in fact, roughly true, or how would you basically look at the due diligence comparing what you're trying to do versus someone else's existing trade dress registration?
This is where it's really important to find a practitioner who understands that particular business and market,
Okay.
so that they have an idea as to the scope of protection. So with patents, it's very important to have that idea. With trademarks as well, you can run searches and determine what the scope of protection actually is or would be. It's a little trickier for trade dress, but if you have someone who understands the industry and how it works and what competitors are doing, then you can have a better idea as to, how wide or how broad that protection is.
Okay, perfect. The next one is about properly using other trademarks that are owned by other parties. Is it a good rule of thumb to continue to use their Circle R or TM accordingly, and then also do a disclaimer? Like, what would you say as like the baseline courtesy if it's in the fair use, non-infringement bucket?
I would say look at the owner's website, or if it's used under license, how they say to use the mark is a smart place to start. A lot of companies will tell you how, or how to use their mark when you need to mark it. It's not always appropriate to mark with a Circle R if, for example, the mark isn't registered in that country. or in that jurisdiction. And so it's really important to either ask the owner or look to see kind of what is the practice in the industry in referring to that particular mark, in terms of how to mark. But it's a very specific ask because it's very dependent on the mark and the owner and how they want you to refer to their IP.
That's great. Now, it feels as though, of course, the majority of these discussions that you're bringing up is really about training the person who's heading the marketing or the corporate communications. What other sort of suggestions, because you're obviously developing them to be more keen on approaching this, that you would suggest? Is it like pulling you in as outside counsel, setting up, advisory sort of meetings or review meetings? Like, what sort of ongoing training outside of this just initial discussion would you recommend those who basically are bearing the trademark and trade dress responsibilities in their companies?
I would have a good internal program in place. I'd mentioned trademark brand guidelines as a good starting point, so that everyone, at least on the team, understands both what you have, which marks are actually yours, and how to use them appropriately. Other good tools are trainings. I have done specific trainings for specific clients addressing various issues within trademark and advertising law for issues that they see most often in their industry or for their particular brand. So that's a good way, is to just kind of do those trainings. Also, I've had clients just send me marketing collateral and say, hey, this is what I want to do. Can I do this? Or do you have, would you caution against making this claim, or referring to this competitor's mark? And so that's where you dig in and you really look at the content and you do an analysis and you see, is this appropriate? And so it's all of that you mentioned, Tara, taking that personal approach, understanding the client's business, understanding really what questions are coming up most often. I can do a high level training like I've done today, and that can be helpful to people who don't know the difference between the different types of IP. Sometimes it needs to be more granular and more focused on a particular aspect of IP or marketing, and so that's important to kind of nail down. And also to just get an idea, if these issues, these questions keep coming up time and time again in the business, it's either there's a kind of a miscue, I guess, in communication, and we need to kind of figure that out and maybe address training to that, or we need to actually, it's a maybe key to marketing to fix that particular communication. Maybe, it's not as straightforward as they're thinking it is.
Yeah, no, and continuing that thought, you mentioned this on a couple of slides ago, which is, social media is pretty big and significant. I can only imagine that it's, scaled the volume of review by 100-fold. But there are ways to note infringement if there's, brand, bad brand usage that's usually regulated by the platform itself. If a startup company does see like problems or such, I'm assuming your recommendation would be, of course, tell the platform, but more importantly, when do they get you involved, or when do they start? You mentioned watch services, so that they're not, the startup isn't losing what they've worked so hard and is so expensive, to protect and to continue to grow and keep clean.
Yes, so I always recommend watch services early in the process. If you file the application and you're on your way to registration, it's a good idea to think about watch services so that you can keep an eye on the application process. As far as social media and monitoring that, you can set alerts. A lot of clients use Google Alerts. That's just one example of the tools that are out there that are fairly cheap or free. You can certainly pay a service to provide reports to you. There are more passive ways and there are much more active ways. You could have someone who's, actively looking online. You can run image searches for things like trade dress, where you're just not, you can't do a keyword search. A lot of the technology out there has come to the point where it's fairly easy to track what's out there. A lot of platforms, as you mentioned, Tara, are going to have ways that you can register your mark. And so that if a third party does start, register your mark, not with the trademark office, but with that particular uh, uh, platform. So for example, there's Amazon brand registry. eBay has its own, brand registry protection program. And there are many, many others. Look at the platforms where you sell the most and see what they have developed to be able to work with you as a brand owner to keep infringing uses out, to keep out, black market goods, things, counterfeit goods, things that, you don't want on there, again, tarnishing your brand. So make sure that you're well aware of what is out there and taking advantage of a lot of those programs, because most of those are free as well. Once you have your trademark registration, you register there as well, and you kind of have another set of eyes looking out for you.
Yep, that's great. Well, and my last question, Tiffany, this has been fantastic, is, why work with Greenberg Traurig? Like, why having a multinational, approach with thousands of lawyers versus someone that is smaller and important to do, especially if you're at such an early stage.
Right. Well, you want to work with an attorney and with a team that is well versed in these areas, that has, the broad experiences and the depth in all of these different areas: trademark, trade dress, patent, copyright. And so a larger firm is typically like Greenberg Traurig. We have a team of over 80 trademark attorneys where this is all we do. And so, within trademark, there are different markets. There are attorneys who have mostly restaurant clients. So, you want to be working with those attorneys because they're going to understand that industry and they're going to know which issues to look for when they're clearing a mark and when they're registering a mark and in enforcing a mark. I, being in Utah, have worked with a lot of clients in the outdoor space. So again, just kind of knowing the environment, knowing what works, knowing what the marketing looks like. These are all kind of questions that come up in clearance and enforcement and in maintaining a brand. And so you want to be working with a team that has that broad range of experience. And it's not that, smaller shops can't get the job done. It's that it's going to be easier and most likely you're going to find a good fit with experience in terms of like dealing with all these brand registries and all the different platforms and all the social media. There are a number of us who've been doing this for long enough to where we can either handle it, or I've got a colleague who's seen it before and we can just pick it up and run with it so that you don't have to spend time spinning your wheels dealing with it. You can make one call and just get it taken care of right away.
Yeah, I love it. And I agree. Like, you want someone insanely experienced to be protecting probably one of the most precious assets that you have, other than, your IP, right? Because, well, actually it is IP. So I take that back. You want the most experienced person to protect your IP, because that's definitely driving the worth of your company, especially when you're still in the conception, phase. Don't have all these other hard assets yet. So, well, Tiffany, thank you so much. This was a fantastic episode. Really appreciate your time today.
Oh, thank you, Tara. I appreciate it. And just happy to be a resource.
Yeah.
Happy to talk about this area, and we'll be talking about the other areas of IP, copyright, patents, and trade secrets. I had mentioned that before is another area that we'll talk about going forward.
No, it's so important. And this OpenUp also concludes with the availability of your slide deck, as well as your PDF, summarizing trademarks and trade secrets. Additionally, Tiffany is available as a mentor to take just conversational calls at any sort of time. You can find her on the landing page as well as find her on LinkedIn, right? Anybody can connect with you at any time.
Yes, definitely. Please reach out. Thank you.
This was great. Have a good one, everyone. Take care.